welcome to this special episode of the Future Money podcast. Today's episode is a really ad hoc one and quite a unique one. The last couple of days, we're recording this. It's May 23rd, 9 p.m. Dubai time, 1 p.m. Eastern time. The last 24 hours, I think I got something over 30 to 40 messages from many of you around the world asking me to clarify and try to provide color on some of the developments we've been seeing in the crypto space that have really accelerated the last week, especially as the House passed the Financial Innovation and Technology for the 21st Century Act, in short, basically what we're calling FIT21. I decided to do a special episode of the podcast to really try to give you guys practical color on what is this resolution, what does it mean, what is the legislative process from now on, and what can be some of the practical implications on it, not only for the crypto ecosystem in the US, but also globally as well. And so if this bill can have the impact that many believe it can have. And to do so, we're very happy to be joined today by Neil Kumar. Neil is joining us from the East Coast, and Neil is the co-head of the Commodities and Derivatives Group at Wilkie Farr and Gallagher. Neil, thanks for joining us on the show today, and thank you for joining us at such a short notice on a pretty busy day in the regulatory and crypto ecosystem in the US.
Thanks, Henri. Happy to join and happy to talk about this very exciting development in our industry. Just a little bit of background about myself. I actually, a long time ago, was in the General Counsel's office at the CFTC when they were implementing the Dodd-Frank Act, which was back in 2010. And there are a lot of corollaries to this bill and what we expect the legislative process to look like going forward. And these overarching market reform bills, which at one point were fairly unusual, and now we're going to do two in the space of about a decade. And so my practice primarily focuses on the CFTC, both regulatory and enforcement, and increasingly over the years has been in the touch point between crypto and the CFTC.
Awesome, and thanks for joining us. I think your practical experience will be very handy today. So let's dive right in, Neil. So maybe can you share for the benefit of our audience, what is FIT21? What is kind of its background, and what purpose does it aim to solve before we go into the details later on?
Sure, and at its core, I would say the issue it's aiming to solve is regulatory clarity. And what is the regulatory regime in the U.S. for crypto? And there have been numerous bills and predecessor bills that have resulted in ultimately FIT21. But at its core, it's meant to provide a regulatory structure for much of the crypto ecosystem and how to deal with other aspects of the crypto ecosystem in the future. And so it creates a regulatory regime for much of the market. And that regulatory regime in general is divided between the Securities and Exchange Commission, the SEC, and then the Commodity Futures Trading Commission, the CFTC. And at its core, that's what it's meant to do. A lot of the issues that participants have faced over the years is, well, am I a security regulated by the SEC? If not, am I a commodity? And maybe the CFTC has some degree of jurisdiction over me. But that's really at its core what it's designed to do. And once you sort of fill in, the structure, you sort of go off in one direction or the other, depending on the provisions of the bill. And so that's really what it's meant to do is ultimately regulatory clarity.
And that's obviously much welcome. I think if you ask anybody in the crypto ecosystem, one of the big complaints they've had was the lack of regulatory clarity, especially in the US. Frankly, I think as somebody who's been in the crypto space now for a decade, and as a lawyer by background, when I look at this, sometimes it becomes comical to see not only the kind of the different interpretations that are often conflicting between the SEC and the CFTC, but also the position that from what the SEC chairman takes to what some of the decisions by the courts. It's been obviously quite a bit of a mess, to be polite. What's your view with this bill? If this bill goes through, do you think it's going to be able to provide the level of regulatory clarity that people have, especially on whether something's a security or not, and also the ongoing litigation matters are in front of the court today?
Of course. So one thing I would caution your audience is we're in DC, so things go a lot slower than everyone's used to, and I think a lot of people would want. The next step for this bill is it's been passed in the House, and for those not familiar with the legislative process, a bill needs to be voted on by both the House and the Senate, and then it goes to the president for signature. So really what happens now is the Senate takes it up, and it goes through a process. And typically, you wouldn't just see a sort of mirror version of the bill agreed upon by the Senate, but it'll go through, it's a Senate process, which will take some time, and ultimately both the House and the Senate need to agree on the language of a particular bill. And so, you know, the way to think about FIT21 is really a starting point for the legislative process, with the Senate going next, and then, you know, depending on how much everyone wants to work together, hopefully you get sort of a consolidated bill that, you know, will contain components of FIT21. You know, whether or not it ultimately looks exactly like FIT21, you know, we'll see. But that's sort of the next step in the legislative process. And, you know, if and when passed, it would then be signed by the president. In terms of when we could see actual regulatory clarity, my background was I was at the CFTC working through the Dodd-Frank Act back in 2009, 2010, 2011. And it's a long process. This bill has joint rulemakings that both the CFTC and the SEC would have to do together. There's a 360-day deadline for the CFTC and the SEC to complete those rulemakings. And having gone through the experience at Dodd-Frank, it had very similar deadlines that ultimately weren't met. The CFTC eventually finished all its rulemakings. The SEC still hasn't finished its Dodd-Frank rulemakings from 2010. So just to give you a sense of timing, it's not like this bill gets passed and suddenly we're all ready to go. There's a lot of work to be done by both regulatory bodies. They also have to some of the provisions of the bill require that they interact and consult with foreign regulators. All these things wind up slowing down the process and taking time. But, you know, I think if we look at passage, we're at least a year out before we ultimately see what the regulations look like. And that's a pretty aggressive timeline. So, it's things take time. Yep. They'll be sort of worked through, but, you know, immediate clarity is not shouldn't be the goal, because it's not what this process would achieve, but it's steering the United States in the right direction where there is a framework to conduct the business.
And it's very interesting. I think this is one of the elements, I think, why there was a lot of misunderstanding in the broader market, right? So obviously now this is done by the House. The Senate should approve it or not. And then it has to go to both the SEC and the CFTC for the rulemaking, like you said. So really this can go on for some time. Based on your experience in the current, let's say, political climate, what are the odds that the Senate would actually approve this bill that's put forward by the House?
You're asking me to break out my crystal ball. I really do wish I had one. The Senate is a very different body than the House, just generally, particularly for your folks overseas. There are over 400 members of the House, and there are only 100 United States senators, and they come at these issues from very different angles. And there are a lot of strong feelings about crypto in the United States, both pro and against. And I would say, just as sort of broad brushstrokes, you're probably generally closer to pro in the House and then closer to con in the Senate, right? As you do these weighings. And so the idea that the bill is just going to be sort of rubber stamped in the Senate, I think everyone should disabuse themselves of that notion. And the most likely outcome is it goes through a fairly lengthy process in the Senate where it's being considered and ultimately being, modified and marked up. And then it's how much can people compromise and come together on a framework. And you're seeing there are competing factions within each party, right? And so I think my sort of general prediction is we're not headed toward a swift Senate adoption, but I think it's very realistic that you get an engaged group of senators that ultimately try and come up with some type of compromise that's, starts with FIT21 as a bill and then works its way toward, a newer version that both the House and the Senate can agree to.
Very, very interesting. Just one thing you mentioned, obviously, in the legislative process, obviously goes to the House, goes to the Senate, and then the president, whoever is the president at the time, has the right to veto such a bill. What was interesting for me when I read the statement of administration policy today that was issued by the office of the president, I mean, literally starts with the administration opposes passage of the bill. But there were a number of mentions in the media that President Biden does not intend of vetoing this bill. In your experience, if both the House and the Senate approve this, for example, what is the odds or of a president actually vetoing a bill that has been approved by both houses?
So it can happen. I would say, given the significant number of anytime you have a greater number of the same party voting for a bill, that sort of increases the likely or decreases the likelihood of a veto, I should say. And so you had, over 70 Democrats in the House vote for the bill. Depending on what the markup might look like in the Senate, if you get a really significant number of Democrats in the Senate voting for the bill, ultimately it's all up for negotiation. And so the way I view statements like that is it's a starting point for the president to sort of lay down a marker, and it's ultimately, as the bill evolves, gets changed. And if we ever get to a point where we see a significant number of Democratic senators voting for a version of the bill, the more that jump on, the less likely it is that we get a veto. And so it's really a marker to throw out there. But I wouldn't consider it sort of, well, any and every crypto bill would be vetoed. It's just sort of laying a ground marker, trying to provide sort of space for negotiation around a bill, and then see where things arrive. And so, again, the idea of a veto on any crypto bill, I wouldn't put much stock in. But it is a signal from the president that they clearly want to see some changes.
And generally, in your experience, I understand there's normally a 365 days timeline for both the SEC and the CFTC to do the rulemaking afterwards. But generally, in cases like these, and I know it's very difficult, but when it passes the House and it goes to the Senate, from a timeline perspective, for example, do you think it's possible that the Senate could approve this before the next elections in November, or it's highly unlikely considering the timeline with the elections coming up?
So in an election year, honestly, all bets are off. Really, it's really hard to predict. You could see a world in which the parties think, well, passing this bill sort of helps us politically, or they could sort of fortify their positions in saying, well, passing this bill is gonna hurt us in some way. And so depending on sort of how they're reading the tea leaves of the electorate, that's going to signal how quickly. My general guess is we're not, going to see Senate passage of a bill this year, but that's really just, sort of putting my finger up to the wind and guessing. But you could see a version where suddenly there's momentum with the idea of sort of capturing more vote share in an election, because that's what these folks do for a living.
It's interesting how, for many years in the crypto ecosystem, there was a movement to try to show that, some of the voters cared about crypto. And I think there's been numerous initiatives like this across the US. So I think it's interesting that in this year in particular, this becomes more of a political topic than actually regulatory or policymaking topic. So I think it's very, very interesting.
Just to mention, I think the number of Democrats in the House that voted for the bill is significant.
Yep,
and that is sort of showing momentum on that side. There hasn't been lack of momentum on the Republican side, but 70 is not a small number. If it had been 20 or fewer, or a handful of House members who voted, that also would have been significant. But the large number that did vote for it shows there is at least some degree of momentum within the Democratic Party to think through crypto legislation and how to deal with this on a go-forward basis.
Very, very interesting. The one thing I have to say, Neil, as I was reading these different documents and statements the last couple of days, I have to say my favorite document, probably in a negative way, was a statement by SEC Chair Gary Gensler. He made a document called Statement on the Financial Innovation and Technology for the 21st Century Act. In there, I highly recommend to the listeners to read the statement that Chair Gensler made. But I have to read one line in there that says, I quote, many market participants in the crypto industry, however, have shown their unwillingness to comply with applicable laws and regulations for more than a decade, variously arguing that the laws do not apply to them or that a new set of rules should be created and retroactively apply to them to excuse their past conduct. Personally, I find this very interesting. I would love, first of all, to get your views on how common is it for a SEC chair to comment on a piece of legislation issued by the House or any of the
Sure.
arms of Congress.
I don't think I'm breaking ground here. It's very unusual. I think it's particularly unusual to come out against a bill. You will oftentimes see a bill get proposed, and then the chair of the CFTC, the SEC, or whoever is the relevant agency, to say we support this bill. It's a little bit unusual for an agency's chair to come out and say I oppose this bill, and the idea that there is regulatory clarity and folks know what to do and they're just deciding not to. I think it's been proven not to be true over and over and over again in various venues. You look at the court cases that have come out. The courts can't figure this out. They have contradicting decisions about whether or not certain digital assets are securities or commodities. You see different agencies like the New York State Attorney General's office can't figure out if Ether is a security or a commodity. And look at the answers from the chair of the SEC when testifying in front of Congress as to whether or not Ether is a security. And that's really all you need to know about how to do the analysis, which is there isn't an analysis. They'll tell you when they decide what it is. And that's not how regulatory policy is ever supposed to work. You're supposed to be given notice and an understanding of how the rules apply and how they work, particularly from a definitional perspective. And when you have the chair of the CFTC saying ETH is a commodity and therefore derivative contracts based upon Ether are regulated by the CFTC, and then you have the SEC, you tell me, what is their answer on whether or not Ether is a commodity? And I think the answer is they're unwilling to say out loud or at least publicly. And so that makes for a process that market participants there's no lane to go in, even if you really want to comply and decide what to do. Because if you go to the CFTC, if it's a security, you still have, you've gone down the wrong path. And so again, what this bill is trying to do is create those pathways. We'll see how things turn out as it goes to the Senate, but it's a great starting point to create some of those pathways.
And I think it's very interesting because exactly that's why I found that comment was very maybe dishonest or whatever from Chair Gensler, saying that the crypto firms have shown their unwillingness to comply with applicable laws and regulations when these laws are not clear. It's very difficult for people to comply. And I think many of the general counsel and CEOs of crypto firms in the US have made it very clear that they want to register, they want to be regulated. But they just want to know why, like how, and that clarity, like as you mentioned, Neil, has not been provided, which is very interesting. The other thing I found very interesting, by the way, in his statement, I mean, I won't go through all the different aspects of his statement, but basically, he criticizes that the Howey test will be removed. He basically complains that the bill would remove the investment contracts that are recorded on the blockchain from the statutory definition of securities and the time-tested protections of much of the federal securities laws. I mean, it's very, very interesting, I think, the commentary that he's been providing on that perspective, from Gary Gensler's perspective.
I mean, I would just say, like, laws are meant to evolve over time, and the Howey test was created in the 30s. And what was life like in the 30s compared to what it is now? And you have Congress coming forward and attempting to provide definitions for folks to utilize on a go-forward basis. And that's exactly the way our laws are supposed to work, is if Congress feels there's a need to update and provide clarity as to how to either apply an existing test or create a new one, that's exactly what Congress is there to do. Yeah. And so there may be disagreements on the scope of the definitions, but the idea that Congress is taking this up and using its authority to create definitions, I think, is a welcome one, particularly in the United States.
Of course. At this point, because it's a bill, there will be clearly, if this goes through, there'll be various reiterations of this document. So I don't think it's worth going into detail But of course, I would say there's a number of things this document, the bill. And by the way, it's I think it's something like 400 plus pages. So I think it's there's a lot of information there. But obviously, one of the things it tries to do is provide transparency and accountability. Basically, it's asking digital asset developers to provide accurate, relevant disclosures, including information relating to the project's operations, ownership, and structure, which is something, by the way, what many other regulators around the world have done. And also, it's proposing to require customer serving institutions like exchanges, brokers, dealers to provide appropriate disclosures, to segregate customer assets, of course, from their own company assets, and really reduce conflicts of interest, provide various disclosures, operational requirements. And I would say there's the two other big elements from what I saw was obviously the one is on the fundraising side, give a pathway for how develop the group teams can raise funds. But I think the most important, like you mentioned, is really provide a clear process to determine which assets are subject to the SEC's jurisdiction and which ones are subject to the CFTC's jurisdiction, and really establishing clear lines between the SEC and CFTC when it comes to digital assets. Which brings me to my question, from your perspective, to what extent is this more of a power grab situation? Because if the SEC has a remit on the asset class, obviously, you can ask for a bit more budget, more staffing, more headcount, and the same goes for the CFTC. How much of this you think is a political and power positioning versus really a matter of law and legal interpretation on where these definitions fall when it comes from a SEC or CFTC perspective?
Sure. So I am in part going to answer your question, and in part not going to answer your question at all. Anytime you're dealing with jurisdiction of an agency, it's always a power grab. Like there isn't a objective legal analysis. Everybody wants jurisdiction over what they can get because it allows you to justify the existence of the agency and request more budget and sort of work this. So that's always at play. I would say this bill, it's complex. And it's working to create a line where a developed digital asset can start off in one sense, and then over time sort of become decentralized and eventually be labeled as a digital commodity. And that's sort of the dividing line, is whether the blockchain is oversimplifying a little bit, but like that you're looking for elements of decentralization, and that's what's setting something in the direction of the CFTC or the SEC. And that's a complex process to do. It's a complex undertaking, and Congress has decided to create a process that recognizes the complexity of that. And again, it gives you a set of criteria. I think getting the CFTC and the SEC to agree, like there's definitions and they have to do joint rulemakings around those definitions. And so what is decentralization, all these factors, that's when and this is leaning on my history, having worked on Dodd-Frank rulemakings, that's when you really start to see the agencies butt heads on who has jurisdiction over what, and when is a blockchain decentralized, those sorts of real in the weeds types of issues. But that's when the staff at the agencies really start to sort of butt heads on who has what. And that's why these rulemakings really, quite honestly, take so long. We worked through, when I was there, the definition of a swap, and that took a very long time. And that was a financial product that had been around for quite some time. And the agency still had, more than a year to argue over what a swap was. And so you're going to see, a version of this bill or this bill that gets passed, you're going to see a version of the same thing play out again in the future, which is the agencies going through the rulemaking process, which is the agencies sort of arguing with each other over what, something like decentralized actually means.
Yeah, this is very interesting, Neil, especially, as you mentioned, a lot of these terms that were being defined post-Dodd-Frank, for example, the term swap, as you mentioned, took literally years, and it's a financial instrument that is very standardized or even commoditized at this stage, no pun intended. And then the idea is, okay, when we look at this, is I have trouble seeing how regulators are going to come up to an agreement on from staking to yield farming to airdrops. I mean, there's so many items that come up that are so difficult to define, and have trouble seeing how, even let's say if the legislative, the Congress gives both the SEC and the CFTC 365 days, a year basically, to come up with the regulations, and the space moves so quickly. that it's going to be very, very challenging from that perspective to get the market intel, the market color, and all the developments and try to fit that in. I don't know what you think of that.
Yeah, no. So that is one of the reasons that the rulemaking process oftentimes takes such a long time, particularly in one like this, where, as you mentioned, Henri, there's so many terms and so many defined terms, and what they actually mean in practice versus what they mean, in terms of the definition of the statute. And I would like to point out my colleague Christian Carlo, when he was the chair of the CFTC, formed what was then known as LabCFTC, which was really a division within the agency that was designed to get the CFTC to understand developments in technology, to understand different aspects of new market structures, and really to be a sort of beacon of information coming into the CFTC. So they would be out there meeting with either market participants, technology developers, anyone that would wanted to explain certain issues to the CFTC, and they could ingest that and see, okay, how does this fit within our regulatory structure? Are there sort of rulemakings that we should be opining on? Are there definitions that we need to understand a little bit better? And what this bill does is sort of codify LabCFTC and makes it a sort of permanent office within that agency. And so kudos to Chris on, having the foresight to create that type of division within the agency, and now the Congress very much recognizing it by codifying it and putting it in the statute, which means it stays there forever. And one of the two other things I'll just mention is within the Commodity Exchange Act, which is the law that governs the CFTC, there is a provision that requires that the CFTC consider, quote, responsible innovation as they develop their rules. And having LabCFTC is one way to do that. And there's another provision in the bill that actually would add somewhat similar language on the SEC side. So when the SEC contemplates its rulemakings, they would equally have to consider how to foster what responsible innovation. And that's probably a lesser talked about provision of the rule, but ultimately is trying to get the SEC on a foot moving forward in terms of how it thinks about its rules, not reactionary, but ultimately forward-looking, and how it can foster innovation.
Yeah, very, very interesting. Well, Neil, thanks for being with us today. I think one of the big takeaways, at least I have personally, is a timeline on this, right? I mean, let's say this passes the Senate, there's approval on it, this goes to rulemaking. I mean, am I wrong to think that, we're at the aggressive timeline of how these rules of clarity will be provided? We're like 2-3 years away still. Is that a fair, you think, timeline of even on aggressive side?
I think that's a fair timeline. I think, in the bill, it's 360 days to adopt the rules. I think that's once the bill passes and is sort of becomes effective in law. So, if that were to happen tomorrow, we're talking about a year, and the most likely outcome is that a rulemaking, as you mentioned, because you were talking about how many definitions they have to work through, how many concepts they have to work through, the law does require it to be done in 360 days. That's just ultimately, in my view, too aggressive a timeline to have it done and done well. And so we're not sort of, a week away, a month away, a year away, but we're setting, it's the idea is getting the United States on a pathway to a regulatory structure.
And the problem here, as you know, crypto is a very global industry. I mean, 2-3 years in crypto is 20-30 years in TradFi, right? So, I mean, if you look at, I'm based in Dubai, where the last year alone, there was not only in the last 2 years, a new regulator was set up for crypto. You have hundreds of applications. I mean, and I see this in Abu Dhabi. I see what's happening in Hong Kong and Singapore. What's happening with Mika in Europe. I mean, I think it's, I think the one thing, I think it's like you said, it's a good step in the right direction, but 2-3 years in crypto is decades. Neil, thank you very much for being with us for this, special episode of the Future Money Podcast. Neil, if anybody wants to find out more about you or get in touch with you, what's the best way?
Sure. So my bio is on the Wilkie website. Neil Kumar, I'm co-head of our commodity and derivatives practice. And feel free to reach out anytime. Happy to hear from anyone and everyone.
Awesome. Neil, thank you very much for your time. And thanks everyone at home. Thanks for all your requests for many of you who messaged me asking for more clarity on this thing. Hope this episode was useful as useful to you as it was to me. Thank you very much, Neil. Thank you very much at home. And see you all soon for another episode of the Future Money Podcast. See you guys soon.